I and I going beat down Babylon. I and I going beat down Babylon. I and I must whip them wicked men. I and I must whip them wicked men. Oh, what a wicked situation. I and I starving. This might cause a revolution and a dangerous pollution. I and I going beat down Babylon. I and I must.
Good morning and greetings to all our viewers out there. Thanks for joining us today. We are very privileged to be joined by our guest, Brett Pollack. He's a legal advisor and consultant specializing in the cannabis space. So thanks for being here today, Brett.
Thanks, Bertie. It's lucky to be here as always.
Yeah, we've had some very exciting movements on the legal front of cannabis lately, and especially with like the whole Pakisa Action Lab and all that stuff that's been happening. Just for our viewers quickly, can we just give them a brief overview of the current legal situation of cannabis in South Africa?
For sure, yeah. It's always a good way to start and to just emphasize for viewers that we still, however quickly it's dying, we are still in, hopefully, the dying throes, as I say, of the prohibitionist era.
Yes.
So we need to remember that very much front and center, as exciting as things are in the industry, that the Drugs and Drugs Trafficking Act still criminalizes pretty much all activities in relation to cannabis, other than where specifically licensed in the medicinal space, in the pharmaceutical sector, or where our private use rights are concerned, right? So remember in 2018, we had the landmark Prince judgment, the privacy judgment as everyone calls it, which gave us our rights to privately cultivate, use and possess cannabis for exclusive purposes of personal and private consumption. And it's within that space that this club and many other clubs on that basis have established themselves in a bona fide way to allow their members to exercise their constitutional rights. We also obviously have the infant so-called hemp sector.
Yes.
And we'll talk about the developments in the Pakisa around how we actually are looking to abandon this word hemp, which is a fabulous piece of progress. We'll talk about that in a minute.
Yes.
But it's important to note that it exists in terms of agricultural laws, in regulations to agricultural laws, namely the Plant Improvement Act. But if you think about it and look at it from a technical legal perspective, as I say, the Drugs Act prohibits pretty much everything in relation to cannabis, other than the pharmaceutical sector, and other than now, since the Prince judgment, these private use rights. So if you think about it technically, even the hemp sector is actually prohibited.
Yes, of course, yeah.
So I mean, that's an opinion out there. It's one that I hold, but at the same time, you know, people are busy getting permits. I think there are around 400 permit holders for so-called hemp, and I say so-called because we're soon going to find out that this word is under serious threat for good reason. So that's generally where we are. Very general overview where the legal, the status of cannabis in South Africa, and we're on the precipice of fantastic times, I think.
Okay, no, that's brilliant. I'm going to return to our conversation in a moment. Just want to quickly double check everything.
Campaigners say they have been given the constitutional right to grow and consume it, but trade remains a fundamental stumbling block. We are talking about cannabis production in South Africa. What is causing the agitation and friction in the country? Let's find out on this next report from Pretoria.
Hundreds of cannabis lobby groups and individuals came together across South Africa to express their frustration against the government on the approach, structure, and pace of cannabis law reform and legal regulation. In 2018, South Africa's Constitutional Court decriminalized personal consumption of cannabis by adults in private.
The effect of the judgment of this court is to decriminalize A, the use or possession of cannabis by an adult in private for that adult person's consumption in private.
But there are still many aspects of producing, possessing, transporting and selling that are still against the law.
The government's apathy and slow dealing of cannabis legislation in South Africa. Our legacy farmers still have no way of growing cannabis legally. We have lots of delays in legislation, and our economy essentially needs cannabis urgently for job creation and to stimulate the economy, especially after COVID. So there is no reason for it to be delayed. It's been 4 years on Sunday since the Constitutional Court ruling, and very little has moved forward. So we are calling on government to speed up and to take this industry seriously.
Cannabis, also known as marijuana or dacha, is one of the most controversial substances that see people divided about whether it is harmful or helpful. But in many rural parts of South Africa, there are certain groups who have been cultivating this plant for generations.
Hey guys.
There are still no solutions for rural legacy cannabis farmers who still remain criminals in the eyes of the law.
The president of the country is talking about an inclusive enabling cannabis legislative framework that will include what we call legacy farmers. We estimate there's between 40 and 60,000 of those, although the master plan talks about 900,000 farmers. These farmers have been farming cannabis for generations, for 150 or if not more years. They have relied on it as a source of income. They have put their kids through school, put food on the table, and the legalization from the Concord that has enabled cannabis for private use has really put these farmers under a lot of pressure.
According to World Health Organization, South Africa is the third largest illegal cannabis producer in the world, growing about 2,500 tons in a year. According to South Africa's Agriculture Department, the size of the local industry is estimated at 28 billion rand or 1.9 billion US dollars. The industry is also estimated to create as many as 130,000 jobs.
Cannabis is not just about puff, puff and pass. This industry has great potential to create employment and investment opportunities in South Africa. Therefore, it is hoped that the process to finalize the legalization goes smoothly and swiftly. This is Calden Olmo from Pretoria, South Africa. For WION, World is One.
Remember back in 2018 when the Constitutional Court handed down the privacy judgment, what they said to Parliament. In a constitutional democracy, you have three arms of government. You've got the courts, the judiciary, you've got Parliament who makes the laws, and you've got the executive, president and the cabinet, the three arms of government who are there to kind of implement the laws.
Yeah.
So at the end of in the order of the privacy judgment, the Constitutional Court said to Parliament, go and fix these constitutional defects. You have a mandate now from us to understand that the parts of the Drugs Act which prohibited the possession and use, private possession, use and cultivation and consumption of cannabis by adults is now unconstitutional. That was a section 4B of the Drugs Act. So to that extent, this legislation is unconstitutional, right?
Okay.
You need to now go and draft legislation to cure these constitutional defects and to flesh out these rights.
Yes.
Parliament then, they gave them 2 years.
Yeah,
But
that's back in 2018, right?
2018, that's when the Constitutional Court judgment was handed down. Then Parliament the courts gave Parliament 2 years to flesh these laws out.
And then sort of nothing happened in that time. We were all stuck in limbo expecting...
Nothing happened in that time, but in late, that was already overdue. Late, they published the first version of this cannabis in September 2020. They published the first draft of this bill when the Constitutional Court said, by 2020, by 2 years, it must be done. Point is, we're still in the throes of this parliamentary debate in the National Assembly. As you correctly mentioned, it's the Portfolio Committee for Justice and Constitutional Development that spearheads the writing of the bill.
Sorry to interrupt you. This bill, what's the right reference? What do we refer to? The private purposes bill? Or?
The Cannabis for Private Purposes Bill.
Okay.
So it's there to precisely, at least originally intended, as a means to flesh out. Because remember, the courts they're not there to deal with millions of different public policy issues. The court is there to adjudicate the matter before it. It can't then create laws. It's not its job.
Okay.
Parliament is our lawmaker. It's democratically elected to make the laws. So the court says, Parliament, now you got to consider all the multifaceted considerations that go into making a law. Use around children, the ways of consumption, the prescribed limits. This is the biggest thing for exercising these rights. How, when, and where can we exercise these rights that the Constitutional Court in principle gave us?
Okay.
That's the purpose of the bill. So now you asked the question, like, how are these public hearings?
Yes.
What's their relevance and
what's that process? So is that part of the entire process to?
Well, that is the process. So as a part of it's a constitutional, it's inherent to constitutional democracy that the public is able to participate in the procedure of lawmaking. We have a very well-defined right to participate. It's called public participation.
Okay, so let me ask you this way: how do you feel about you have obviously been following this quite closely. How do you feel about the participation? Do you think we had a good effort there?
Parliament has the duty to write the law in terms of the Constitution, but it's a big jump from that point to putting limits on the amount of ganja that can be possessed. Okay? What the Department of Justice needs to justify is, one, why you would put a limit and whether the limit is constitutional.
Where's the credible scientific and academic evidence upon which this bill is based? And why are there questions right now that are very, very basic questions when it comes to the THC contents and the nature of the cannabis plants at this late stage in the drafting of this bill? Are we to expect the passing of this bill through Parliament to proceed without such evidence? Who is going to come and count my dacha plants? Will the South African Police Service be charged with counting, measuring the plants, measuring the THC levels of an estimated 20 million South African cannabis users, cultivators, and traders in order that they can enact the irrational and unconstitutional criminal penalties suggested in this bill?
Inclusion of industrial cannabis or hemp in the Cannabis for Private Purposes Bill is nonsensical. The Cannabis for Private Purposes Bill is supposed to deal with private use only, not industrial or commercial purposes. Cannabis for industrial and commercial purposes should fall to the DTIC and DELRA, as cannabis is an agricultural crop or commodity. The bill should not be used as a legal instrument to fix inherent issues in the Plant Improvement Act.
Some of the regulations that the more modern ones we see in the European Union and the United States Farm Bill, they actually define hemp by THC levels. Traditionally, we haven't defined hemp by a THC level. We have defined it by how you use it. So if we're wanting to use what we've got, which is tens of thousands of hectares of traditional farmers growing landrace cannabis, for industrial purposes, it's not essentially hemp, it's industrial cannabis. And if we keep saying we're going to use hemp and we're going to define it by THC, it is automatically excluding that plant, that genetic, and those farmers from the industrial value chain.
The scheduled harms of THC that's used in this bill to justify the types of criminals. What exactly was presented to you that made it seem logical, if not scientific, that one molecule could be defined in three different ways: public, private, medical, non-medical, religious, non-religious? And yet you have three different chemical effects, and in some settings, those chemical effects would require criminalizing citizens. What science was presented to you that made this logical?
I'm fully informed regarding the 2023 draft cannabis bill, which now also features hemp clauses and also clauses regarding cultural and religious use of cannabis. I'm fully informed about the health-giving benefits of cannabinoids from Cannabis sativa. I know that these plant cannabinoids enhance and enable the human body's endocannabinoid signaling system, and that cannabis dacha is a health-giving plant, whether taken as recreation, nutrition, prevention, or medicine. I'm fully informed about the nutritional value and health-enhancing value of the seeds and seed oil of cannabis. I'm fully informed about the fodder value of the stalks and foliage of cannabis. I'm a member of the Dagga culture of South Africa, which was prosecuted and persecuted by the state since 1923 until the Constitute Court judgment in 2018, and ever since. And I inform you that the present draft Cannabis for Private Bill purposes bill is rejected in total by myself and the Dagga culture of South Africa today, and the bill shall be adamantly resisted, and the bill in its present form is outside the mandate of the judgment and must be completely revised before tabling to Parliament to accord with the Constitutional Court judgment and basic human rights upheld in the Bill of Rights.
We need the freedom just to move forward, because we can't take it, we can't repair the pain, but what is important is to move forward with a life. That's what we are asking. We request the Parliament to consider legislation that focuses on rural regeneration, including existing traditional farmers.
I think it's important to realize that the Umzimvubu Farmer Support Network was specifically formed 7 years ago in response to what Chief Discourse from the Maklinki community and traditional authority raised in respect of this government's aerial eradication program of the Amapondo cannabis. So the Umzimvubu Farm Support Network was formed to provide support to those farmers who had suffered for 20 years this government's program spraying cannabis or glyphosate on cannabis. We were successful with that legal intervention and strategy, and we now serve the purpose of making sure that we can bridge the gap between the poorest of our poor in rural Pondoland and this government. And indeed, we engage with local government, provincial government, and as we are here today, engaging at the national level. Unfortunately, Chair, it does seem that our previous submissions, specifically in respect of hemp, were not taken into account, because with respect, Chair, had they been taken into account, this bill wouldn't factually refer to hemp, because quite clearly the heading itself speaks to say that it's only intended to regulate the personal and private use and cultivation of cannabis, not the commercialization of hemp. So whilst we do welcome the insertion of these hemp provisions, we do submit that they are misaligned. And perhaps what is very important, and the Portfolio Committee will appreciate, that the intention of the legislator is critical when drafting legislation and interpreting it once it's eventually enacted. And it's clear to me from a consideration of the minutes of the sitting of this committee on 23 November 2022, that amongst the members themselves, there is much uncertainty as to why these hemp provisions have now been included in a Cannabis for Private Purposes bill. Members were specifically asking whether there is not redundancy and unnecessary reference to hemp, bearing in mind the amendments that have already been made to the Plant Improvement Act. Members also wanted to understand what the linkage between the bill and the Plant Improvement Act was. We would have then expected, Chair, that before this bill went out to civil society for broader comment, that it would have been accompanied by a briefing note from the State Law Advisor to explain exactly what the intention of the legislator is to now include these hemp provisions in this Cannabis for Private Purposes bill. That would have been, with respect, the appropriate way to deal with it. So, Chair, if I can then go on and still confining my submissions to hemp, the Amapondo farmers, as Chief Discourse rightly indicated, have used cannabis for hundreds of years, not only for spiritual, cultural, and adult use purposes, medicinal purposes, traditional medicine purposes. They've used it for industrial purposes, which is exactly what hemp refers to. Hemp is not a different plant. It is the same cannabis plant, Tsango, Dacha, Umya. And they use it for industrial purposes. Chief mentioned how they would use it to make their cars. They would use it to reinforce the building of their rondavels. So it's quite clear, and it's fundamental that the Portfolio Committee understands and accepts this, that the Amapondo indigenous cannabis farmers already use their indigenous landrace cannabis for industrial purposes. Now, Chair, with all respect, these additions of these hemp provisions seem to be a cure-all to try and cure the defects that already exist in the Plant Improvements Act. So on that basis, we will submit that they are entirely inappropriate. But one thing, Chair, and noting members of comments from some of the members that there is this rush, and specifically Kusato's comments too, that there is this rush to pass this this bill within the next sitting. Chair, I would say, particularly in light of the most recent State of the Nation address by Honourable President Ramaphosa, that we shouldn't be rushing anything. The deadline of the Constitutional Court has already passed. To avoid this bill being enacted and ending up being litigated for many years to come because it is potentially still unconstitutional and hasn't been drafted with a human rights lens and framework in place, it is certainly not going to enable what President Ramaphosa publicly stated, is that he's shortly going to be actioning, and I understand that it has already been actioned, a process to put in place what the President called a whole plant, all legitimate purposes framework. So this bill, Chair, quite obviously is not that framework. Indeed, this bill is going to do more harm than good, and it does remain unconstitutional in too many respects. And with all due respect, Chair, this bill does take us one step forward, which is towards a regulated cannabis industry, yet 1,000 steps backwards at the same time. And to perhaps lean on the logo that Chief Discourse from Maclinty community had on his presentation for his community trust, he uses the word "siya phambili," which means forward ever, backward never. But with respect, we are going backwards and we are not going forwards to the place where cannabis can be liberated for all legitimate purposes.
So if you look back to the beginning when the bill was first introduced in Parliament in 2020, we saw immediate knockback from civil society in the public participation hearings that were held to enable our right to participate.
Yes.
And from the beginning, Russ Gareth Prince, Fields of Green, all the regular and soldiers in the industry rightly complained how this bill, from the beginning, if it was enacted in that form, would be attacked in total.
Yes, we would almost be worse off than we are now.
So a lot of people would say that. I'm not sure whether I think we'd be necessarily worse off, but certainly the bill in that form that it was originally, and even in the form that it's in now, would still perpetuate state invasion, because what it says is that the original and the current form, because remember, every time there's a public hearing process, everyone gives their comments from the public, then the portfolio committee goes back and takes it into account, and then there's a new version, proposed version that is circulated for the next round of. So all the way through up until now, the bill basically said that they're prescribed limits, right? So essentially, for example, 4 flowering plants an individual could cultivate living alone, for example, and anything above that was like a trafficable quantity, and everything above that was a commercial quantity. And there were a whole bunch of other, in relation to cultivation plant material like seeds, propagating material, how the quantities you can possess alone in private, the quantities you can possess living it with more than one person in private. All these quantities were the portfolio committee tried to insert in this bill.
Remember, throughout, people were very hesitant with that. They were like, stop the plant counting.
Exactly.
It's unconstitutional.
Exactly. So it's all about this idea that the Constitutional Court said, right, we have this right. The state doesn't have any legitimate interest in invading our inner privacy when it comes to these types of things. And then the Parliament comes and basically, by prescribing these limits and saying how anything in excess of those limits is a crime, you basically allowing continued or perpetuating state invasion and allowing police to come knocking on your door and count your plants.
Yeah.
So the trick here is that the Constitutional Court did say that it's not for us, the courts. As I said to you, the courts don't deal with policy-laden issues.
It's for the Parliament.
It's for lawmakers to do that. So the court did say that it's not for us to prescribe limits. That's for Parliament to do. So that's what they said, right? But does that mean that Parliament must make limits? The answer for me is no. All the court is saying is that it's certainly not for us to do that. If anyone's going to do that, that's Parliament's job. But that doesn't imply that Parliament must go
must
there and
have limits on the...
Parliament needs to understand the constitutional imperatives of the judgment, which is to decriminalize private use. So they can't then, in the same vein, criminalize private use, especially when you consider that, okay, it's one thing for me, example, if I personally, 4 flowering plants at any time is more than enough to satisfy my personal consumption needs, and I don't consume that much.
But maybe for someone that's got a bigger illness, they might need a larger amount, and that could also be for personal use.
Correct, and some people might need to create concentrate forms in order to. Not everyone smokes it. And most, like significantly, I think the vast majority of our population, or at least millions of people in South Africa, don't live in a nice big space like this, where they live. A lot of people live in shacks and informal settlements, right, where people are sharing spaces, and people don't have the private space, firstly, to cultivate their own, and moreover, would be using a single space to be cultivating a whole number of plants. Right, and now if we're saying essentially to the police through this bill that you can come and knock on our doors, it's unconstitutional. It's going to perpetuate the criminalization and the stigmatization of the cannabis community. So from the beginning, when it came to the public hearings for the bill, everyone screamed and shouted rightfully that this is nonsense. Like, we're going to there's no point. Let's just scrap this whole thing. We're going to attack it as soon as it's passed.
I remember there was a lot of opposition from public side. They were not happy with the bill.
Yeah, and they haven't. So the Parliament hasn't listened. When you ask the question, how do you think that process has gone? Yes. I think it's been very hopeful in the sense that Parliament is listening.
Yes.
Parliament is listening.
And the right things are being addressed.
And the right things are being canvassed in public and in public hearings, but they haven't thus far caved and surrendered on that plant counting point, and that is the major thing. That is the major. They've listened in respect of a lot of other points, which we can go into.
Yes.
The bill also had, in more recent iterations of the bill, they included provisions for the commercialization of the hemp sector.
Yes.
And for the adult use, so-called recreational, that word must die as well.
Yes.
It's an adult use market. People use cannabis for a million reasons, not to just have fun and have a laugh with their chommies.
Okay, that's true, yeah.
But the point is that the bill, remember, this bill is made by a justice committee.
Yes.
The Department of Justice and Correctional Services.
Yes.
They're not the Department of Trade and Industry. They're not the Department of Agriculture. They don't understand the plant. Why are they trying to retroject, through this bill, clauses that really have a lot to do with trade and commerce and agriculture?
Yes.
They don't have that expertise, but you have to. We must also understand. We must also understand that from the beginning, a lot of people came forward when commenting on the bill, and I was always questioning how this was going to be done coherently through this bill, which is supposed to decriminalize. It's
still looking at it as
criminal laws,
yes.
even though it's decriminalizing. It's Department of Justice thing. It's decriminalizing. It's still in that realm. So decriminalizing something is still something that sits within the realm of
justice. Yes.
But trade and industry and agriculture isn't. So, but you have to understand that people in the public came forward and said, "This is nonsense. We need to legalize the plant." In making comments on the bill. So to some degree, I understand how the Portfolio Committee then went back and listened and tried to insert these clauses that to me make no sense in this bill when it comes to the commercialization of the so-called hemp sector.
But it was still done from more of a justice perspective as opposed to...
Well, it was done, to be frank, from a non-educated perspective.
Yes.
So you've got these regulations in terms of the Plant Improvement Act that give so-called effect to the hemp sector. Now this bill isn't marrying with that, and as I said earlier, those regulations, if you look at it technically, are meaningless and illegal until we liberate the plant from the Drugs Act. The whole industry was stillborn. Firstly because, as I keep mentioning, it was criminalized in terms of the Drugs Act. The Drugs Act doesn't envisage a hemp sector, for
industry,
example. And number two, because of these ridiculous barriers to entry, such as a 0.2 THC maximum threshold percent in the flowering leaves and buds. It's impossible to grow cannabis in this country with that little THC. It is basically impossible. We all know that THC is the plant's like sun protection. With our UV rays, we're never going to establish. Even if we have a seed that's promised in from abroad, which is another issue, that they say there grows at less than 0.2% THC. It's never going to do that yet.
No.
And guys have been growing THC, a very viable cannabis in Pondo land and many legacy farmers for many generations, almost 1,000 years. That is just now not viable. And other barriers to entries too, like security perimeters and fencing and marking and all these things, that it's going to be impossible for so many other legacy growers to comply with. So I don't know when you want to start talking about this Pakisa, but
yes, exactly.
But
That's where it all leads up to. Yeah, so we recently had the Pakisa Action Lab. I'm just going to take a peek here on the screen.